One of the best laws Congress passed to protect victims of domestic violence is the Violence Against Women Act, also known as Vawa. The act allows battered and abused spouses of United States citizens and lawful permanent residents to self-petition for permanent residence in the U.S. The Vawa self-petition is confidential, and neither the abuser or any parts of the U.S. government will be informed of the initiation or the decision on the case. Moreover, USCIS has a special victims unit in Vermont Service Center that handles these petitions. In this post, I will discuss the Vawa self-petition process. So what is the Violence Against Women Act? As I mentioned above, the Violence Against Women Act is an act that protects victims of domestic violence. The immigration provisions include the self-petition process that I spoke about. It also includes a special rule for cancellation of removal and removal proceedings. The law also established several waivers which are exclusive to the victims of domestic violence, including a waiver of an admission to qualify for permanent lawful residence. In other words, even if someone enters the United States without admission or inspection, which bars others from adjusting, a Vawa self-petitioner still qualifies for adjustment status. The law also allows a conditional permanent resident to remove the conditions unilaterally if they or their dependents were abused. So you may be wondering, who may apply under Vawa? The following individuals may apply for self-petitions: spouses of lawful permanent residents and United States citizens who are subjected to abuse, parents, father or mother of a United States citizen who were abused by their children, children and stepchildren who are subject to abuse. In the case of stepchildren, the parents must have been married before the child's 18th birthday. So what are the requirements for a Vawa self-petition? There are several requirements of which self-petitioners should be aware. These requirements include that the person was abused by a United States citizen or lawful permanent resident, they were victims of battery or extreme cruelty, they were abused in the United States, or in some situations the abuse happened abroad, but the location is considered U.S. territory, like an army base. They should also demonstrate good moral character, which means no convictions, and prove that their marriage was entered into in good faith. So you might be thinking, is that person eligible for adjustment of status? Applicants under Vawa are eligible for adjustment of status once the I-360 petition is approved. The application process is the same as in other adjustment categories. The petitioners and their derivatives may apply for adjustment concurrently with the I-360 or may wait until that petition is approved. You might be thinking, can I naturalize? So Vawa self-petitioners actually do not have to wait for the 5 years to get their naturalization. They can apply under the 3-year rule. That's a special exception that Congress put together for Vawa self-petitioners. You may also call me at 1-888-963-7326 to talk to me about the Vawa process and see if you qualify. Thank you.